I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And we've got a lot of new docs that have hit the summary, one that has hit the actual court docs. Of course, it's sealed, but it tells us a lot, and I'm going to break it down for you here in this video. It's not hard to figure out what's going on in the case. And there are some things that are happening that, I mean, some can consider good, others maybe not so much, but we're going to break them down because I know that there's a lot of people out there that's going to mess them up. So we're going to get right on top of this before it can get messed up too much. This is some serious happenings, what's going on right now. And there's a little bit of bad news in it as well, because as I covered several days back, a victory. It was a victory. You know, the judge, as I clearly pointed out, had given the defense access to those grand jury transcripts finally. That's what the order was on the 6th. Whenever the judge cites 1911, that's to deal with the grand jury. The defense has been after access to the grand jury transcripts, the full transcripts this entire time. And he granted them access to it. John Judge would never do that. Well, there's been some things that have happened now since then. And today, the judge posted on the court docs an order sealing his order staying something. It can only be one thing. And as I go through the case summary and I apply the only thing it could be, it appears that the judge has stayed his ruling on the defense getting access to those grand jury transcripts. And let's talk about, here, we'll look at the doc real quick, and then I'll show you what a stay means, and then I'll show you why it applies to what we're talking about. Okay, so here's the new doc that is hit, and it's an order sealing an order. Okay, so he's not sealing the order that he already ordered, which was giving the defense access to the grand jury transcripts. He's sealing his order staying an order. So that means he's sealing an order of him ordering a stay. And he dated it June 9th, 2025, and it's sealed. And we know it's to do with the grand jury transcript because, again, he cites Idaho Code Title 19, Chapter 11. And that's not Chapter 11 bankruptcy. That's the grand jury proceedings. So he ordered that the grand jury proceedings would be accessed by the defense finally. Now he is staying that order for some reason. Well, let's talk about what a stay is. Okay, in Idaho law, a staying order typically refers to a court order that temporarily suspends or postpones a legal proceeding, judgment, or enforcement of a judgment. It essentially puts things on hold until a certain event occurs, like a court ruling on an appeal or until a motion is decided. Purpose. A stay can be used for various reasons, such as allowing parties to pursue an appeal, to prevent the enforcement of a judgment pending a review of the case, or to address a specific legal issue. Now, stays are temporary. They're generally temporary and not meant to be permanent solutions. A court will typically lift the stay once the reason for the stay has been addressed. The stay that he issued is absolutely related to the order that he granted the defense to have access to the grand jury transcripts. Now, that's the first part. Now, there's other things that have hit the case summary, though, that are of great interest, I believe. Now, this is where things really heat up and get interesting. And this I'm kind of loving. All right, so when we go to the case summary, we remember that there was a motion by the state to exceed the page limit. They filed their motion to continue, or opposition to the defense's motion to continue. I had people out there disagree with me on the fact that they wrote an opposition to rather than an objection to, but I'll agree to disagree with their assertions. But then immediately following, we get this. This is huge, y'all. This is the state's objection that was filed right on time to the defendant's offer of proof for alternative perpetrators, and this and right here is huge, and defendant's evidence in support of, that should be offer of proof, not officer of proof, alternative perpetrators. So the prosecution has filed two separate objections, one to the defendant's offer of proof for alternative perpetrators and a completely different objection to the defendant's evidence in support of the offer of proof for alternative perpetrators. Then let me show you why this is so huge. They filed that under seal, of course. But then the next thing we see is a motion to redact or seal newly filed record, and it's a motion for independent analysis of evidence. This is by the defense. Obviously, in the state's objection to the proof of evidence in support of the alternative perpetrator, they must have put something in there, because you can bet this proof of the offer of proof of the alternative perpetrator included in the defense's proffer includes some type of DNA analysis of the alternative perpetrator. Now, this could be blood on the handrail. It could be blood on the glove outside. It could be DNA from underneath Maddie's fingernails. It could even be something to do with the four brothers that were named in the IGG investigation. But you can bet it has something to do with the DNA of one of those perpetrators being linked to the alternative perpetrator. And in the prosecution's objection, they obviously objected in some way strongly. They had a strong objection to the defense's offer of proof. And that's why the defense immediately after receiving their objection files a motion for independent analysis of evidence, because they want this alternative perpetrator offer of proof to stand. And they have to have an independent analysis of their evidence if they did some type of DNA testing or genetic genealogy search of their own. So an independent analysis of evidence would confirm that. And the judge immediately proposed an order granting the independent analysis of evidence. And then motion to seal, stipulation in order for additional trial exhibits. That doesn't matter. Proposed order granting the trial exhibits. And then the defense files a motion in order for emergency order. So let's talk about how this stuff actually plays out. What is independent analysis of evidence? Okay, in Idaho law, independent analysis of evidence typically refers to the review and examination of evidence without reliance on or undue influence from a specific source, individual, or entity involved in presenting or generating that evidence. Here are the key scenarios where independent analysis of evidence is crucial. In a judicial review, when the Supreme Court of Idaho reviews certain cases, such as death sentences, it's required to independently review the evidence to ensure the sentence is not based on arbitrary factors and that the evidence supports the findings. Expert witness testimony. Idaho Rule of Evidence 702 addresses the use of expert witnesses who can provide scientific, technical, or specialized knowledge to help the court and jury understand the evidence. Their analysis are expected to be independent and unbiased. For instance, genetic tests can be ordered by the court and performed by independent experts to determine paternity. Forensic analysis. In criminal cases, forensic scientists perform analysis of evidence samples and may need to testify as expert witnesses, performing independent analysis based on scientific methods. Medical or scientific evidence. Idaho law recognizes medical or scientific evidence as evidence found in sources such as peer-reviewed scientific studies published in medical journals that meet recognized requirements for scientific manuscripts. This implies the need for independent peer review to ensure scientific validity. And then it gets into overdose immunity. But in essence, independent analysis of evidence in Idaho law is a mechanism to ensure fairness, accuracy, and impartiality in legal proceedings and decision-making processes. It requires that evidence is examined critically on its own merits, free from bias or external pressure. You can bet that the alternative perpetrator proffer of proof included DNA from one of those sources linking the alternative perpetrator, and the state freaked out. Now the defense want an independent analysis of the evidence to back up that it does match that particular person. This is getting big. However, it doesn't stop there. The judge proposed an order granting the independent analysis of evidence. I don't know how they're going to do it that fast before the June 18th hearing, but maybe they can. And then they went through additional exhibits that are going to be admitted at trial. But then on June 6th, motion to seal, defendant's motion, and order. So the judge ordered for an emergency order. What did the defense freak out for and want a emergency order for? That is very interesting. And then we've got the response from the state for defendant's motion for independent analysis of evidence, but it doesn't matter because the judge already has a proposed order granting the independent analysis of evidence. Boom, right there. So, and that was on 6/6. You can bet the state's response came before the judge's order. And then, but then the judge ordered a staying order, sealing the staying order, and that can only be for the grand jury transcript because he lists 1911. But what the heck is the defense motioning for an order for an emergency order for? And what is an order for an emergency order? Let's look at it. Okay, we've got in an Idaho criminal case, a judge issuing an emergency order, also sometimes called an ex parte temporary order. So an ex parte, that means if the defense is wanting an emergency order ex parte, that means it's out of the ears and eyes of the prosecution. This would be something that is strictly between the defense and the judge. Very interesting. But it means the judge is acting quickly to address a situation requiring immediate action to prevent serious or irreversible harm. Key aspects of an emergency order: issued without prior notice or presence of the other party. Bam. This means the order is issued based solely on the information provided by the person seeking the order. So the judge issued the order and it came from the defense, so that means it was just the defense and the judge issued it outside of the presence of the prosecution. It's a temporary duration. These orders are not permanent and generally last for a limited time, such as up to 14 days until a full hearing can be held where both sides can present their case. Purpose: the judge issues this type of order when there is a belief that an immediate action is necessary to protect someone from imminent danger, such as in cases involving domestic violence, stalking, or harassment. I wonder who the defense is trying to protect. And examples of situations where an emergency order might be issued: domestic violence, child protection, stalking, or harassment. It's important to note a full hearing is required to determine if a final order should be issued after the emergency order expires, and opportunity for the other party to respond. The party against whom the order is issued will be served with the order and notice of the upcoming hearing, giving them an opportunity to respond. Oh my goodness, you know what this could be? So in essence, we've got really three major things happening here, but I believe two of them could be pretty much tied together. First, there can be no doubt. The defense files their offer of proof for the alternative perpetrator. The prosecution objects not only to the proffer for the alternative perpetrator, but also for the evidence that the defense submitted as proof of the alternative perpetrator. The defense immediately files for an independent analysis of the evidence. The judge grants it. that can only mean that the defense included in their offer of proof DNA analysis tying someone to the scene, y'all. I've done many videos on this. The defense had access to not only, they got Bicca Barlow on the team, but they also had, as an expert, a gentleman who ran a lab that specialized in forensic genetic genealogy, creating the sample. And then they have Vargas on their team that is noted by a lot as one of the best people in the country for performing the genetic genealogy search. So with those two people on the team, all they need is a DNA sample, and they'll figure out who the heck was on that DNA sample if you give them enough time, and they've had 2.5 years. So that means that they could have tied the perpetrator, the alternative perpetrator, to the scene with either DNA on the handrail, DNA on the glove, the DNA found underneath Maddie's fingernails, which that's typically, who gets arrested for a crime such as this. Or it could have been through the genetic genealogy search that Othram did, where it led to 4 brothers before the FBI got involved and did something behind the scenes that was, out of everybody's eyes, and they won't disclose to get to Bryan Kohberger, which is very suspicious. But the original genealogy search by Othram that led to the 4 brothers, that could absolutely be part of this. The prosecution immediately files an objection, not only to the offer of proof, but also, not only to the alternative perpetrator proffer, but also their offer of proof. Defense immediately files for an independent analysis. Judge grants it. Huge. Absolutely huge. That means alt perp. That stuff's coming into this trial. This thing's getting big. But then we've got the defense filing for an emergency order, and that's an ex parte order just between the defense and the judge. I have to believe, because the judge then suspended the access from the, for the defense to have access to the grand jury transcripts until a hearing, that to me all paints one big picture. The judge granted access to the defense for the grand jury transcripts. I've said this entire time, in those grand jury transcripts is going to be the name of a state witness and what they testified to. The defense from the beginning has said they will corroborate Bryan Kohberger's alibi through cross-examination of a state witness. But then when they couldn't get access to the grand jury transcripts, they X'd out that state witness from their alibi statement. If the judge granted them access to the grand jury transcripts, they would have access to that state witness, and that state witness, we all know, is controlled by the state. So the defense files for an emergency protective order so that the state cannot, put their pressure on that state witness to not tell the truth. But then the judge stays the dang protection, he lifted the sealed order that gave the defense access to the grand jury transcript. So it's kind of like a circle of chaos right now. So this is getting really interesting though. But I wanted to break all that down and let you know the fireworks that are happening right before our eyes. And if you weren't very familiar with this case, you wouldn't even know the fireworks were happening. They'd be going off in silence. But for those of you that follow me, we will never be in silence, and they can't hide anything from us. They pop it on a case summary. We're going to sniff it out. Please like and subscribe to this channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.